Good afternoon, members of Parliament, support staff, radio listeners, TV viewers, those following via social media, and members of the media. Welcome to this public meeting number 18 of today, Friday, May 5th, 2023. I would like to give a special welcome to the Prime Minister and the Minister of General Affairs, Ms. Sylvia Jacobs, and her support staff. We have established a quorum of 11 members. Please stand for a moment of silence. Thank you. Also, I would like to welcome the members from the SARE committee. I have received notice of absence from the following members: MP Angelique Rumu, and a notice of lateness from MP Peterson. Are there any other notifications? No need. The agenda point for this public meeting are 1. Incoming documents, and 2. Draft National Ordinance amending the National Ordinance Social-Economic Council to expand the scope of Council's advisory function, Parliamentary Year 2021-22-163, IS 1285/2021-22, dated September 5th, 2022. We go over to the agenda point 1. All members have received the list of incoming documents and the proposals for further handling under IS/561 until IS/695, Parliamentary Year 2022-23. Are there any comments on the proposals on the list as presented? No need. If there are no comments, the list and the proposals for the handling are approved. We go over to the agenda point 2. Draft National Ordinance amending the National Ordinance Social-Economic Council to expand the scope of Council's advisory function, Parliamentary Year 2021-22-163, under IS 1285/2021-22, dated 5th September 2022. The draft National Ordinance amending the National Ordinance Social-Economic Council to expand the scope of the Council's advisory function was received on September 5th, 2022 by Parliament. A Central Committee meeting was held on April 3rd, 2023 on the subject matter, in which the members of Parliament posed their questions and the Minister answered these questions. A report has been made on the deliberations in the Central Committee meeting and was sent to the government, as well as to the members. The government answered this report with a so-called note following the final report under the document IS/740/2022-23, dated May 4, 2023. All members have received a copy of the draft National Ordinance and the note following the final report digitally via email. These documents can be found on the P drive of the Parliament. At this time, I would like to first give the floor to the Honorable Prime Minister and Minister of General Affairs, Ms. Sylvia Jacobs, for her introductory remarks and our presentation. Prime Minister, you have the floor.
Honorable Chairman of Parliament, honorable members of Parliament, Secretary General of the SER, as well as support staff and my support staff of Parliament, and of course to the people of St. Martin, a good afternoon to one and all. Today, Mr. Chairman, I'm not sure if the presentation is ready. You didn't have a presentation.
The meeting will be adjourned for 5 minutes. Meeting adjourned.
It was mentioned that it was sent to Gary.
Welcome back, and the presentation is up. And Honorable Prime Minister, you have the floor.
For the technical glitch, I'd like to continue by stating that today we are here to seek the approval of the proposed amendment to the National Ordinance of the Social-Economic Council, known as the SER. These changes are integral to the National Ordinance itself and are of utmost importance to the role and working method of the SER. The changes, as have been proposed, are geared towards preventing legal technical imperfections and aims to create a broad legal basis for the optimal use of the SER. As we know, the SER is an advisory body tasked with advising the government on matters of socioeconomic nature. It is a tripartite advisory body made up of employers, employees, and independent experts. Meaningfully, the SER employs the broad-based concept of welfare, which is essential for the stable and enduring development of our country. Some of these changes, Mr. Chairman, to this Landsverordening Sociaal-Economische Raad ter uitbreiding van de reikwijdte van de adviesfunctie van de Raad are based on the first court verdict in the case brought by the ECSM on June 29, 2022. The SER has followed due process to have those changes vetted by the Department of Legal Affairs as well as the Council of Advice before presenting them here in Parliament, both in Central Committee meeting, which took place on April 3rd, 2023, as well as in this meeting, public meeting of today. Hence, with the understanding that any change of the SER law will pose concern for our country based on its organic nature and the fact that all of these changes have significant impact to the National Ordinance, I ask for your attention to summarize the current situation as well as the proposed changes to the National Ordinance of the SER. This presentation was prepared and presented by the chairman of the SER in the Central Committee meeting, former chairman of the SER in the Central Committee meeting of April 3rd, and no main changes to the content were made other than the date. The presentation will address, oh, you're doing it now. Sorry. The presentation will address 4 key areas, being the current situation, the need to amend the National Ordinance, the legislative changes, and lastly, the consultations. The current situation in dealing what is the task of the Council is based on the National Ordinance of the SER Article 2, Paragraph 1, to provide the government with advice on all significant matters of a socio-economic nature, which I mentioned in my opening statements. The Council at this moment does not have the legal provision to advise Parliament unless it goes through government. Which organization or foundations have legal authority to be represented? As I mentioned before, employees, which are represented by unions under the WICLU, Windward Island Chamber of Labor Unions, with 3 members and 3 substitutes. The independent members, also 3 members and 3 substitutes based on Article 3, Paragraph 5 of the National Ordinance SER, who are appointed by the Minister of General Affairs, and the employers, who are currently served by 2 employer representatives, namely the Swaliga Employers Association, SEA, and the Employers Council St. Martin, ECSM. They also have employers, 3 members and 3 substitute members. Ideally, as in the case of the employers, both represent employers. It would be best, of course, just as the labor unions have done, to jointly appoint the 3 members and substitute members. And we hope to one day get to that point. The current procedure concerning the allotment of seats is based on Article 3 of the National Ordinance, whereby, as I mentioned before, the WICLU put forward their nominations, the employers do the same, the General Affairs Minister does the same, and then they're appointed by national decree put forth by the Minister of General Affairs and, of course, signed off by His Excellency the Governor. The level of confidentiality at this moment can be improved as was discussed by the former chairman in the Central Committee meeting, with the example that he gave where confidential information from meetings were being read in the papers, and also further elucidated in the notes following the report that was provided by Parliament earlier this week. Why is the amendment necessary? It has become quite apparent that the current text of the legislation for the Social-Economic Council contains some ambiguities. It is also desirable to implement legislative improvements in this national ordinance in order to avoid future ambiguities in the text. That it is also desirable to expand the scope of the national ordinance whereby Parliament can also request advice from the Social-Economic Council, and to avoid future litigation regarding the seat distribution between the stakeholders on the council. And I do take note that the chairman further elucidated all of the changes in the Central Committee. So I will just go down the list. The Article 2, paragraphs 1 and 2, which dealt with the institution and task. Article 3, the design and composition. 6, the membership. 8, the grounds for dismissal. 10, chairperson and vice person. 11, the secretaries. 12, the term and reappointment. 13, the invitation for the first meeting. 16, relatives, blood relations. And 18, deals with confidentiality. Also presented back in early April, Mr. Chairman, members of Parliament, were how these amendments came about. There were consultations with the Department of Legal Affairs and Legislations, as well as with the Council of Advice, and in collaboration with the Social-Economic Councils of both Aruba and Curacao. Since that presentation, further consultations have been ongoing for the draft national decree that would be necessary as a result of these amendments for the criteria to be established with regards to the membership of the SER in line with that of Curacao and the Netherlands. So that is being done also together with these entities with a similar or same function. So that's basically the changes that have been proposed, Mr. Chairman and members of Parliament, as were presented before. And of course, I understand that this august body knows and understands the importance of the SER in our young country. I've received requests via you for members to have certain research done and advice giving. And it's always important for us to allow the voices of our employees and employers to weigh in on socio-economic matters, so that when decisions are made here in Parliament, it takes along all concerned. As mentioned, the changes are crucial to the role of the SER as well as their functioning, and it is geared towards preventing legal technical imperfections that have been identified. The changes further aim to create a broad legal basis for optimal use of the SER, also allowing, as I mentioned, Parliament to request advice from the SER. I trust that the information provided, both in the Central Committee, the finalized report, as well as summarized today, have informed the members sufficiently. However, should further elaboration be needed, the Secretary General, as well as even the former chair, is here to assist me to be able to respond to any questions that may be had. And I thank you for your attention and look forward to any further deliberations within this body.
Thank you, Prime Minister. The allotted speaking time is 20 minutes in the first round and 10 minutes in the second round. And according to the speakers list, I don't see anybody has signed in. MP Solange Duncan, you have the floor.
Thank you, Mr. Chairman. A good afternoon to you. Good afternoon to my colleagues in Parliament. A good afternoon to the Prime Minister, her support staff. A good afternoon to the Secretary General of the SER. It's a public meeting. My apologies. And a good afternoon to the people of St. Martin tuned in. Mr. Chairman, I only have words of congratulations, assuming and feeling and knowing that this law will pass. I know that the SER, the board, management has been waiting for these changes for quite some time. Not only do our advisory bodies, but even us here in Parliament, we need to evaluate the last 13 years since 10-10-10 and look at ways in which our organizations can be improved. So for me, the SER is an example. Now making some changes to the law so that not only their work can be improved, but they can also help us here at Parliament, because I was one of those MPs that have asked for research from the SER in the past. And so I'm happy that I have now direct access, but also just happy that the SER can move on, move forward, and work more effectively, the entire organization. So I'd just like to say congratulations and looking forward to supporting this law. Thank you.
Thank you, MP Solange Duncan. The next person I have is MP Melissa Gums. MP Gums, you have the floor.
Thank you, Mr. Chairman, and good afternoon to you, to the representative of the SER, the Prime Minister and her support staff, to those joining us, to my colleagues. Mr. Chairman, I'll just keep it very brief. I have three main questions regarding this law. If I look at the November 2022 Landsverordening, the terms of the existing SER board members did indeed expire on the 30th of April. So my main question then is, what is the process? Can we get an update on how the process is going right now to replace these outgoing board members? And it was mentioned in the presentation that consultations have been held with the Department of Legal Affairs, Council of Advice, the SERs of Aruba and Curacao. I just wanted to ask what consultations have been held with the employee and employer organizations regarding the changes to this law to verify that they would be able to provide members within the turnover timelines required by the changes, because that's also, I think, something that we need to consider. A lot of times you'll see maybe not a lifetime, but at least a 5 or 10-year appointment, specifically because turnover is required. But can these organizations handle basically fill in 18, seats every couple of years? And finally, what is the concern that litigation has taken place and might continue? I don't know. Following then the introduction of these changes based on what has happened historically till now. Thank you, Mr. Chairman.
Thank you, MP Gums. The next person is MP Rolando Bryson. MP Bryson, you have the floor.
Thank you, Mr. Chairman. A good afternoon to you, the Secretary General, my colleague members of Parliament, and a special welcome to the Prime Minister, the members of the SER, and those viewing. Mr. Chairman, I would like to first thank all involved, so the SER as well as the government, in terms of getting this legislation, and then even after having had the opportunity to interact with the SER in a meeting, even finding some additional things that could have been adjusted to improve the legislation of the SER for them to do their work, which has been included by means of a note of amendment that is now part of the legislation that we're handling. Especially welcoming in this law is the fact that members of Parliament will now sort of have a direct access, or the Parliament itself would have direct access to be able to get advice from the SER. In the past, as you know, Mr. Chairman, we would have to do so via the government. I think that formality being adjusted is a good one. I did have one question in that regard. I did mention in the Central Committee, but perhaps if some thought can be given into this aspect of members of Parliament requesting advice now from the SER related to initiative legislation, so particularly that. So not necessarily if you just kind of want some research or an opinion paper or an advice from the SER, but specifically with, my question is about the initiative legislation. If we would like the SER to review it, can the SER indicate any sort of time frame, if that can be, if it is some sort of internal policy that could be given to the Parliament, just so that because the logical thing to do would be to go to the SER first and then to the Council of Advice. The initiative legislation process or legislation in general is already a lengthy one. So it would be handy if members of parliament have an idea of what would be the expected time. Is it like 4 to 6 weeks? Something like that that can allow us to have our own planning and a sort of an expectation, not that it might take, months, I don't know, or as if within that time frame we get an indication that, look, we need an additional X amount of weeks, just as a sort of a courtesy, but also maybe more so a policy that regards to handling initiative laws that come from members of parliament via the parliament to the SER, that response can be handled within a certain time frame to make sure that we don't extend too far the time it takes for initiative legislation to be handled. Thank you, Mr. Chairman.
Thank you, MP Bryson. The next person I see is MP William Marlin. MP Marlin, you have the floor.
Thank you, Mr. Chairman, and a good afternoon to the Honorable Prime Minister and the members of the SER and colleagues in Parliament, viewers and listeners, and visitors in the Public Tribune. So, Chairman, I am rather short, probably shorter than all the others. In this first round, I just have one question in terms of where does the SER now fit in the scope of bodies advising government? We have a number of high councils. Does the SER now become a high council? Because I believe that would require a change in the Constitution. So the SER just remains where it is, an advisory council, but now just with the ability to advise Parliament directly. I thank you, Mr. Chairman.
Thank you, MP Marlin. Next person I have is MP Sarah Westcott Williams. MP Westcott, you have the floor.
Thank you, Mr. Chairman, and I want to thank the Prime Minister on behalf of the government for presenting answers to questions asked by members of Parliament via, as you mentioned in the introduction, Mr. Chairman, via their note of answers. Mr. Chairman, in my questions on the topic, so the changes to the ordinance that regulates the workings of the SER, I attempted to get from the government and assisted by the SER if the government feels it necessary to further elucidate, I use the word delineate, the obligation to consult the SER. Now, the word delineate might have created the wrong impression to the government regarding my questions. I did not want and I did not ask that question to curtail the government asking the SER's advice, but rather to make sure that the government is committed to asking the advice of the SER on all social economic matters. That's the point I was getting to, not to curtail and say these are the only things. And the answer seemed to have been going in that direction, the direction of no, there's absolutely no need to do that, and the SER is being consulted. I wanted to know if the government and the SER feel the need to somehow, whether it be by some type of a protocol or otherwise, establish the obligation to consult the SER on the matters falling under the socio-economic term, because that's a broad term. And I could imagine, and I've seen it, and I've wondered in several cases where decisions were taken by the government, and I have wondered, but why would not the government consult the SER and ask the SER's advice on these different topics? So given that, why my questions in the Central Committee handling of this draft law were like, should there not be some type of a protocol, some type of an understanding, taken also into consideration that what we're seeing more and more are decisions taken by a minister, and not just decisions, so not the regular, so to speak, individual MRs, no, rather MBs, but also meaning specific decisions by the minister, but also general decisions, the MR decisions of individual ministers. And when you have this, I, just looking at it from the outside, feel and see decisions taken that I think should be presented to the SER and ask for their opinion, and it is not done because I don't see or hear of the reaction of the SER, of representatives of workers and employers on different matters. So given that part of the elucidation, to once again ask if there should not be, in the view of the government and the SER, understanding that the scope, to make sure that the things that really need a SER's advice are advised upon by the government requesting the advice. So, Mr. Chairman, yeah, if I would like, I just wanted to sort of rephrase my question. I saw the answers provided by the government, but I think that it was misunderstood what I was getting at, so hence my rephrasing of the question. Thank you once again for the opportunity, Mr. Chairman.
Thank you, MP Sarah Westcott-Williams. I don't see anyone else, and basically I see there are about 6, 7 questions. The Honorable Prime Minister, how much time would you need to prepare? Are you? Honorable Prime Minister needs 15 minutes, so we adjourn for 15 minutes. 3:15 will resume. Meeting adjourned. Welcome back. I give the floor to the Honorable Prime Minister and Minister of General Affairs, Ms. Jacobs, to answer the questions posed by the members of Parliament. Honorable Prime Minister, you have the floor.
Thank you, Mr. Chairman. Thank you, members of Parliament, for your questions. And of course, to the SER Secretary General for the support in the responses, as well as support staff. I acknowledge the congratulations on behalf of the SER of the Member of Parliament Duncan in making the necessary amendments to improve the functioning, and we will continue to do so as we move along and also hear from members of other possible changes that could be made in future. From MP Gums, the question regarding the terms of the existing board members, update on the process to replace the outgoing board members. As a result of, well, of course, we all know the intention was to have this legislation handled in time for April 30th, but seeing that it had been delayed, we have already sent out letters via the SER to the employers and employees representatives to start the process to nominate their members, as is customary. As I mentioned earlier, they nominate 3 members and 3 substitutes, taking into consideration the amended proposed amendments. So in that doing, they would have to then assess whether any of their sitting members are still eligible to sit another term, and of course, whether they're willing to sit another term, and then put forth those names. And similarly with the Minister of General Affairs, government in that regard. So we are also looking at the eligibility of our sitting members and ascertaining their willingness to continue and looking to finalize that process, seeing that we know this process will take at least another 4 to 6 weeks for the review once it is finalized. With consultations having taken place, or which consultations have taken place with the employer and employee organizations that make up the SER board. During the meeting, all the changes concerning during the meetings of the SER, all of the changes concerning national ordinance were discussed in board meetings. These discussions were ongoing since 2019. The SHTA, prior to them establishing an employers association, had written several letters concerning this matter since back then. And prior to 2020 and 2023, the term of this government has been engaged. Prior to this term, government has been engaged with employers in discussion concerning the seat distribution. We have written several letters explaining our position as well, and I think all who were present at least would have been updated on the changes that had been discussed here in Parliament. Those were the last of the changes, correct? What is the concern? What are the concerns after these changes take place, or whether there will be any concerns after? As far as we're concerned, with the goal being to remove ambiguities, and having already 2 verdicts rendered regarding complaints that have been made that are in favor of government, we're hoping that with the ambiguities removed and more clear definition of things that were up for grabs for discussion, and having a national decree determine the membership and how it is distributed, or the criteria for such, that is based on best practices and what is already taking place within the kingdom. We believe that that should minimize it. Of course, people always have the right to do what they want to do, but even the SER Netherlands has taken its position that, and indicated that SER St. Martin has the competency to deal with whatever may come up in this regard. So I believe it's up to the employers to respect the fact that both organizations, just like the labor unions, and it was mentioned that in the Netherlands, I believe there are 33 members, but many more organizations. So they decide together who are nominated. So I would like to just appeal to the employers associations to sit together, either create a new umbrella, or together in a joint meeting, appoint the 3 members according to their membership. Thus far, we have been going based on the number of members. So the association with the most members got 2, and the one with the lesser had 1. So they will have to then, if they don't come to an agreement, the same would take place in the future appointments. But as government, we're open to dialogue to ensure that all voices are heard. Any petition to remove any entity would then be silencing the voices of a group of people, and I don't believe that anybody would want small businesses and the like to be silenced in this type of an organization. MP Bryson is also very happy with the ability to be able to consult directly with the SER, but questioned whether the time frame that Parliament can take note of when requesting initiative legislation, the policy regards handling initiative laws, including the process and time frame. So as soon as we finalize the reappointment of the board, the Secretary General requests the new board to establish such a policy. In the meantime, the Secretariat will prepare a proposal, which will then have to be, of course, approved by the board. So in the meantime, the Secretariat does its work, does its research, awaiting the board to be finalized to take decisions on it. In the meantime, okay, I said that. As customary, urgent advices will continue to receive priority from the SER. The SER also agrees that a clear distinction should be established between government and parliament advice for requests as it pertains to urgency and time frame of the advice to be handled. And I do recall that in our notes to the report that we mentioned the 4 weeks and then getting back to you if that wasn't feasible, and informing as to the required time so that Parliament can plan its meetings accordingly, and that remains. MP Marlin wanted to know where the SER stands now, or where it fits in the scope of bodies now advising government, and does it become a high council with these amendments, or does it remain in the same position with the added task of advising Parliament as well? At the moment, and as you know, government, the SER does render advices to Parliament. It just has to go through government. With these amendments, there's no reliance on whether the government is a government you support or don't support. And as a matter of fact, I have forwarded all requests, regardless to which MP submitted them. But of course, there's no guarantee that that will be continued. That would depend on the government that's sitting. So it is good that we give the members of Parliament the opportunity to request directly. And it remains, the SER remains an advisory body, as that is determined by the Constitution. And so any changes that need to be made would have to be made at that level. And if we want to solidify the SER as a mandatory advisory body for particular matters, then and remove any sort of doubt as to the weight it holds, this should be done when we are looking to adjust our Constitution. And of course, that would be a much broader discussion. MP Westcott Williams thanks us for the note and the responses, and wanted to further elucidate the question asked. Broadening the scope of advices that government would request from the SER. I can agree that government feels an obligation to further consult, and has been consulting a lot more than I think in the past with the SER. We've done so voluntarily, as well as after receiving advices, whether it's from the Council of Advice or His Excellency the Governor, who co-governs with us. So even in the Council of Ministers, when you have meetings and a certain impact is noted, the question is asked, did we receive an advice from the SER? And just recently, we sent back something that was proposed to get a SER advice as well, because of its impact, and not because, you know, an outside entity said it, because we felt it was necessary. So we feel that as government, that this proposal can be further studied as was presented by the Member of Parliament in discussion with the Department of Legal Affairs and Legislation, and we can further also deliberate with the entities, as has started with Aruba, Curacao, the Netherlands, and see how they are dealing with that in terms of broadening the scope, similarly to how we do the national decree to set the criteria the SER setting policies, I believe we can also set a broader scope in that regard with one of those instruments after the necessary consultations has taken place. As this, of course, will put further pressure on government to respond to SER advices in the right manner. So even so, other bodies advise, and it's not a binding advice, but you have to clearly elucidate when you deviate from SER advices. And it's elucidate properly, and of course, the House of Parliament holds you accountable to that. So with that being said, I believe I've responded to all of the questions asked in this round, Mr. Chairman, and I wait further instructions from you.
Thank you, Prime Minister. Does any member of Parliament have any point of clarification? I see MP Gums. MP Melissa Gums, you have the floor.
Just one, Mr. Chairman. Thank you, and thank you to the Prime Minister for the answers so far. My second question, Prime Minister, was more on from a consultative perspective, dealing more with the capacity issue. So did the employer and employee organizations share any concerns about their ability to actually sustain the new turnover timeline for the membership? Thank you.
Thank you, MP Gums. Prime Minister. Prime Minister, you have the floor.
Okay, so the discussion wasn't had in terms of whether it would be difficult to source, but I leaned to my advisor to ask because she reminded me about a number of members of the different organizations. And I know one has over 400 members and the other 5+. So I don't think it should be difficult to source persons to serve on the SER from that perspective. Currently, we have about 5 or 6 labor unions that are much smaller than an organization of employers, and they are able to source, I think, the persons to be on the board without a problem. I think the challenge is more persons seeing the weight of it, and I think when people see the value of being on the board, because it is quite some work, there is quite some reading to do, and you have to have an interest in it. And so I think the content of the work is valuable, and I'd like to encourage persons who are interested, especially from our perspective as government, as independent professionals, to be appointed to indicate such via a letter of interest directed to Prime Minister PM Cabinet at stmartingov.org as well. But we will find out if that is a problem, but it has not been noted to be a problem thus far.
Thank you, Prime Minister. I don't see any other for clarification. We go over to the second round, and it's MP Duncan, no need. The next person is MP Gums. MP Gums, you have the floor.
Thank you, Mr. Chairman. And it's not so much a question, well, one question, but more of a comment on what was stated regarding the pool of membership from the different organizations. I think that thinking that a pool of whether it's 400, 500, et cetera, or 100 is the pool that we have, it really depends on the criteria that is going to be set forth in the coming LBHAM. So that pool of 400 could become a pool of 10. Is the point that I was trying to make with my initial first question. And just if we could receive, Mr. Chairman, the final full text of especially Article 3, because there are some changes mentioned in the nota, but I don't have a full view of what it actually states. And so just to kind of soothe, I guess, the concerns coming from the employers' organizations, if we could receive that and then have that clarity provided. Thank you, Mr. Chairman.
Thank you, MP Gums. The next person is MP Bryson. No need. MP Marlin. No need. MP Westcott. MP Westcott, you have the floor.
Thank you once again, Mr. Chairman, and thanks to the Prime Minister for the answers provided. Mr. Chairman, through you to the Prime Minister, the issue as presented by the note of amendment that we received to the draft presented by the government deals with establishing by national decree containing general measures profiles for the members of the SER, starting with the chairperson and then the members as well as the substitute members. And where the non-independent members are concerned, so in other words, the representatives of labor and business, the government indicates that they will establish profiles. The government also indicated that I don't know if they came to this idea or they had an idea and they checked it out with, amongst others, Curacao, where they have profiles for these persons. And since the government, through the Prime Minister, alluded to the letters that have been sent out to the organizations at this time for the proposals for membership in the SER, and now I paraphrase the Prime Minister saying that in those letters, consideration has been held or consideration has been given to the conditions that are going to be applied to members. So very specifically, is the government of the intention in establishing this decree, national decree containing general measures and establishing profiles, is the government intending to do that in accordance or taking a copy of or similar to the existing national decree of Curacao for profiles for the representatives of the labor sector and the business sector? That's my question. And if that is the case, so what has been included as a sort of a precursor to this decree in the letter going out to the organizations for proposals for membership now? So what has been included in this letter, in this invitation to propose persons? What has been included in that letter that ties into the decree which will come with profiles? That's question one. In establishing, when it comes, in establishing the national decree containing general measures, is the government of the position that profiles should be established a la profiles of Curacao? Is my next question. And if that is the case, when it comes to the representatives of the different organizations, I am not talking about the chairperson, I'm not talking about the independent members on the SER. I am talking about those members who are to be proposed by one, labor organizations, business organizations. And for those members, how, if the government is going to follow the footsteps of Curacao where these profiles are concerned, how will it be ensured that who will check that the proposal that comes from the labor organization, the business organization, meets the criteria as established? So who will check and say, well, no, this person does not have X amount of years experience in the macroeconomic, et cetera, et cetera. So I need some clarity with respect to the intention as put in the note of amendment that we got with respect to the appointment of members. That's one part of my questioning. Secondly, I had asked the SER in the meeting via the Prime Minister in the meeting of the Central Committee on this topic regarding the work that the SER has done until now as far as pension schemes and a pension scheme for St. Martin is concerned. And I did receive the answer to that question and got the information that there are two proposals regarding pension, a pension scheme for a general pension scheme for St. Martin, and also based on my question about a draft that is now in circulation on Curacao, a draft national ordinance that is in circulation on Curacao regarding a general pension fund, a general pension rather, for the inhabitants of Curacao. And in the answer, it was stated that this will be looked at or looked up maybe even. And so my question with respect to that answer is whether the SER organization is still pursuing the idea and the proposal of a pension fund, a pension scheme, a pension program, if you wish, for St. Martin is one part of the question. And the second part is, has any follow-up already been given to checking on the draft law that I mentioned that is in circulation on Curacao? As I mentioned during the previous discussions, we would not have to reinvent the wheel. And therefore, my suggestion at the time that at least some attention, an eye is kept on the proposal that is on Curacao and is doing the rounds as far as legislation, etc., is concerned. So, Mr. Chairman, if those two matters can be further elaborated upon, then I would want to thank you for the opportunity.
Thank you, MP Sarah Westcott-Williams. That was the last person on the speakers list. Honorable Prime Minister, do we need to adjourn for 5 minutes? I'll give 10. Meeting adjourned till 3:53.
Good afternoon, members of Parliament. We had adjourned and to be back for 3:53 or 3:54, but there's a little technical error that was discovered in the draft law. It is being corrected at the moment. It would require an additional 30 minutes, so we will adjourn until 4:40. 4:40, we will be back. Good afternoon, members of Parliament. It is 5 o'clock and we reopen this meeting. The meeting was adjourned to give the Prime Minister some time to prepare answers, and then the Prime Minister requested additional time to make some adjustments to the draft that the Prime Minister had presented. So to answer the floors and to elucidate on the changes, we give the Prime Minister the floor. Prime Minister, you have the floor.
Yes, mic is hot. Thank you, Mr. Chairman, for the opportunity. Though the questions did not necessarily require longer than was requested, in responding to one of the questions, it became clear that there is something that would leave ambiguity within the note of wijziging, which could be rectified. And so we're happy that Parliament afforded us the opportunity to do that, to further clarify the intention of the amendment and the nota. As such, I'll go into the answering of the clarifications or the question. The criteria, MP Gums asked whether it would decrease the eligibility of members and wanted to know how that list wanted more information on the criteria list that is being proposed by the SER. The criteria is still being worked on. I think MP Westcott also asked a question related to that. It's being worked on by the Secretariat, having had consultations with their colleagues. Once it is finalized, it will then be vetted by the Legal Affairs Department, and then we'll have to go through a full vetting process with the sitting board. So the intention, as I mentioned, was for us to have this done earlier so that the board that would be sitting at the time would have done this, but we are late. As such, that criteria will not apply to those who are coming in. They will be the ones to establish the criteria. MP Westcott, and in so doing, in reading the note of wijziging, it looked like it was only referring to one group of members, while the amendment of the criteria would be for all members. So we ensure that it does not just mention Article 3 but it would actually add an Article 3A that defines what happens there, which you will note in your updated version. MP Westcott Williams asks whether it's the government's intention to establish the same LB that I mentioned about the profiles, which is in Article, will become the new Article 3A. It is being what was included as a precursor to this decree and the letter sent to the employees. So the letter that was sent to the employees is a regular letter that mentions the amendment, but of course the LB is not done yet. And nothing was sent to the board on the criteria as yet, as it has, the national ordinance would have to be finalized first. So once it is finalized and established, then, and the decree is also finalized, as I mentioned in answering MP Gums, this will be sent on to the board for vetting approval. In establishing the national degree, is the government in agreement with the profiles that it should be in the likeness of those of Curaçao? How will the government ensure that the proposal meets the criteria as established? The SER has consulted with their colleagues and are in the process of adapting the criteria that they have in draft from the other countries. The criteria will have to pass the scrutiny of the board, as I mentioned before, and this was not possible before the law was passed. This will be done with the newly proposed members, as I mentioned before, to be made on future board members. The decision will then affect future board members. The other question related to the General Pension Fund of Curaçao. Is the STER still pursuing the idea of a pension scheme for St. Martin? Has any follow-up already been given on checking checking on the draft law on Curacao, is SER keeping an eye on the occurrences on Curacao. Once the new board is appointed, I must say the Secretariat continues to do its due diligence, of course, but once the new board is appointed, this will continue to be put forward to them. Additionally, in the report that was submitted, the note to the report, it was noted that the SER is busy reviewing the proposed changes on Curacao. So they are constantly monitoring that as well and will offer an advice to the new board once it comes in. Mr. Chairman? Those are the answers, as well as the elucidation pertaining to the updated note of wijziging. Thank you.
Thank you, Madam Prime Minister. Does any member have or request a point of clarification? No, I see none. We are at the end of the Yeah. So we have therefore now come to the end of the deliberations on this agenda point. And according to Article 57 of the Rules of Order, we now go over to voting on the draft National Ordinance amending the National Ordinance Social-Economic Council to expand the scope of the Council's advisory function. Parliamentary year 2021-2022/163. We will vote on Articles 1 and 2. The title, the consideration, the draft in its entirety as modified by the Memorandum of Modification registered under 743/2022, incoming document 743 of the parliamentary year 2022-2023, dated today, May 5th, 2023. Does any member request voting by roll call, the so-called hoofdelijke stemming? I see no request for hoofdelijke stemming. The law is therefore, the draft law is therefore accepted unanimously. I would like to thank the Prime Minister and Minister of General Affairs, Ms. Sylvia Jacobs, and the members of the SER and her staff for their presence here today and providing the necessary information. Ladies and gentlemen, members of Parliament, we have come to the end of this public meeting. I thank you all for your participation, and I hereby close this meeting.